Hi Sharon, how are you?
I'm not too bad, thank you.
Good, glad to hear it. Right, so you're head of our family law department, and obviously in the news recently there has been coverage about an increase in inquiries, clients going to solicitors about domestic violence, largely due to the lockdown. So I suppose it's a while since I've caught up with you and what you're doing and your side of the practice. I thought it might be a good opportunity then to have a chat about what you're doing and I suppose about domestic abuse in particular and how we're able to help clients at this time.
Yeah.
So, yep. So that being the again, I suppose when I sort of qualified over 20 years ago, domestic abuse was very much seen as sort of physical abuse, but that's sort of changed now. Domestic abuse is a sort of much wider definition, isn't it?
Yes, that's right. It's more wide ranging than just physical violence. It can be a threat of physical violence. It can be coercive control, where you are having somebody who is manipulating you, questioning the things that you're doing, questioning memory that you may have of an event to say, for instance, that's not correct and that you're wrong. Um, People being put down by their partners, civil partner, spouse, whoever it may be. It can also be that the other person has financial control over that person's income. It could be that there is a joint account and they're only allowed so much money out of it to pay for what they deem is essential. And it really ranges for a lot of different things. So it's not just the physical side of things anymore. It's expanded with the use of social media and those outlets too. It can also be that if people are being abusive towards someone online, that would also be taken into account.
And actually, yeah, you mentioned social media there. I know some of the things that you've been talking about, sort of, questioning your memory of things, maybe questioning something the way that you do it or what you may have said or something like that. I think they're calling that gaslighting. And that's something obviously on social media you do sort of find people sort of chipping away at your character or your honesty or your integrity or your reputation. And that's something you've sort of seen happening more recently, I suppose.
Yes, certainly it would be, and especially with the current situation where people are now more into social media and they are they're more involved with various different aspects of social media. So you've got various outlets of Facebook, Twitter, anything like that. It's certainly evolved anyway.
Yeah, funny. One of the things you mentioned there, I mean, we're obviously looking at this in terms of lockdown at the moment, and we normally sort of think of sort of spouse, civil partner, but the sort of definition of who you can get, well, who can actually be guilty of domestic violence, um, that's a much wider sort of definition now. Is it anyone in the household, or how wide is that definition?
Yes, for terms of obtaining an order against someone, it can be anybody in the household. So you don't have to be in a partnership with that person. You don't have to be married to them in a civil partnership living. It simply can be somebody that you are living with. And it can also extend to someone you're not living with, but that is a member of your family.
Okay. Presumably then, if you're in rented accommodation with other tenants, so for example, university students, if you're living in the property as the same household, can you then get protection under the domestic abuse legislation from potentially other tenants?
You could, if you are living it together in the same household, if it was obviously separate um, rooms within a building that you're completely separate, then no, you wouldn't. But if you are all sharing a house, then yes, you could get an order.
Okay. Okay, that's good to know. Okay, so now we know who potentially can be the subject of an order, and we know what sort of behavior or actions can actually constitute domestic abuse. Um, if you take instructions, and I know we'll talk about that just in a while, but once you take instructions, obviously then what happens next? Is it a case of going to court, or how does that work?
Yes, well, initially we would take instructions and then you make your application to the court. If something has happened recently, usually within the last 7 days, you can do that as an emergency application, and that's called an ex parte application. That means that you make your application to the court and you don't put the perpetrator on notice of that. And that would be your application then initially to the court for an order in an interim order for a certain period of time then for that.
Okay, so that person doesn't get notice of that and they don't appear anywhere in the court. Obviously, we'll talk about physically going to court or not physically going to court at the moment, but in an emergency sort of thing, then they're not made aware of this. It is essentially the client going to the court in some format to get the order.
Yeah, that's how it works.
Okay.
And once the order is granted, then it would be the police would then serve that order on the perpetrator, and that's when they would get notice of that.
Okay, we're talking about orders there. What sort of orders are we actually talking about?
Yeah, there are two types of orders. There's a non-molestation order and an occupation order. The non-molestation order is the order which most people will apply to the court for. That order is the order that would stop someone from intimidating, harassing them, threatening them. They can't come near that person. Sometimes what the court will do is they'll actually add an exclusion zone to that non-molestation order. So if, for instance, the person isn't living, the perpetrator isn't living in the home with that person, the court can say, well, that person has no reason to be near that house. So therefore, they're going to put an exclusion zone around, say, if it's a cul-de-sac, around that cul-de-sac or within so many meters of that property. So that non-molestation.
Yeah, and that's part of the non-molestation order,
yes.
as opposed to the occupation order. So what's the occupation order then? Which that's the other kind of order, isn't it?
It is, yes. The occupation order is if, for instance, the two people are living in the same household, then the occupation order gives the applicant, the person applying for the order, the right to reside in that property. So essentially the courts say the perpetrator is to be removed from the property and is not to return again. That is done by, as I said earlier, the police will go and will serve the order on the perpetrator. If the perpetrator is still in the property, they will ask them to leave. They will serve the order and they will give them so long to be able to get some belongings and to leave the property. Now, in that instance, with an occupation order, you're obviously removing somebody from their home. So what the judge will want to know is, does this person have somewhere else to go? Do they have another house, or do they have family members? Do they have somewhere that they can go if they are removed from that property?
Okay, but to be clear, even though at the moment, at the time of recording anyway, we're in pretty much still in lockdown, a court can still remove a perpetrator from the family home?
Yes, they can, yes.
I think that's important to actually say, because it's not something which necessarily is talked about, but yeah, I mean that is the case.
Yeah, that's right.
Okay, in terms of court then, how's that working at the minute? Obviously, I know from previous experience, and you've been with our firm since it started in 2009, and there were certain days where you were not in the office because you were down in court doing non-molestation order and occupation order applications. During the lockdown and the pandemic, how's that working? Is court functioning at the moment, or what happens?
Courts still function, and that is the applications for non-molestation orders and occupation orders are deemed an emergency application, and so the courts are still dealing with that.
Okay.
It's almost slightly easier for the applicant to apply, because the usual course of things was that the applicant would apply and the applicant would have to go down to court to give their evidence initially for an ex parte application. Now the courts obviously are closed to the public, so they are dealing with that simply by way of a paper application. So it's an administrative application initially to start off with, rather than actually having to be present at court or via video link.
Okay, and actually on that point, I think I saw an email coming around from the court service it would usually be the case that a client would come in personally to see you, and they would have to actually physically wet ink sign the application. Both of those things are now obviously slightly different. We know from our point of view, our office is presently closed to the public in compliance with the regulations, and we're doing our meetings by Zoom. In fact, the way we're having this chat, do clients don't necessarily now have to wet ink sign the applications at the moment? Is that right?
That's right.
Okay.
Ideally, in an ideal world, they would have access to a printer and they would print the statement off after we have taken instructions. They would sign that and they would scan that back to us, which we would then lodge with the court office. But the court recognised that obviously people are possibly doing this via Zoom on their phone, and they don't have access to a printer. So what they are accepting, the court will accept that the person has read through the statement. There is a declaration which they simply have to email back to the solicitor to say that they have read it and that they confirm that it is true and correct. And the court are accepting that initially as a way of moving forward to apply for the order.
I suppose, and that's an interesting point. I know in many areas of law, even those now sort of different ways of doing things, it's still the case that certain laws have to be maintained in terms of how documents are executed. But in this instance, the courts actually have shown a degree of flexibility. Do we think that that's potentially going to continue after the pandemic and lockdown, or do you think that it'll sort of revert back to the old way of doing things? It's an unfair question, but I wouldn't want you to get too comfortable sitting there.
No. In an ideal world, they would relax it slightly, but I think we don't know what the new normal is going to be. If the new normal is that people can't get physically into an office, certainly until such times as the offices are physically open, that somebody can actually leave that statement in, the courts will accept that. At the moment, we just don't know what the future is going to be.
Okay, so we've talked about what domestic abuse is. We've talked a bit about the court procedure. I suppose the next thing to talk about, which everyone wants to probably think of, is the actual costs involved. So tell me a bit about the cost. There's a legal aid route and there's a private route. Tell me about the legal aid route first of all, Sharon.
Okay, well, if you're on benefits, then there are certain benefits that are a passport benefit, which means you automatically get legal aid as of right because of those benefits. If you are on a low income, you will also be eligible for legal aid. That is up to a certain amount that you would be eligible. If you are over the normal legal aid income level, then there is another scheme called the domestic violence scheme, which legal aid have offered, and they offer it just for non-molestation orders and occupation orders. So if your income is slightly above the normal level, the threshold level, you would possibly still be eligible for legal aid under this scheme, but you may have to pay a small contribution towards the costs of that.
Okay, is that a new thing? That's not something that I was actually previously aware of. Is this just a pandemic thing, or has this been going for a while?
No, it's been going for a number of years, but usually people will fall within the legal aid limit. It's generous enough, but certainly it was really set up because there were some people that were just falling outside of the scope of the normal legal aid for the advice and assistance under the legal aid, and they just didn't have the means to pay for that by way of a privately paid matter because their income just wasn't sufficient for that. So legal aid came up with this scheme. As I say, it only covers then the domestic violence aspect of things.
Okay, so if people have maybe been turned down for legal aid or have been told they're not eligible for legal aid on other matters, that wouldn't be a bar to this. They should really speak to you and make sure one way or the other for definite whether they fall in or without the domestic violence scheme.
That's exactly it. And again, a bit like the application, it used to be that you would have called to the office, you would have had to have filled out legal aid forms, signed them in our office. That's obviously not happening now. Again, they can be sent over, they can be printed off, scanned back. If the person doesn't have access to a printer, again, they can send an email with information. We would give them the information that they need to send back in an email. to confirm that they again accept that what we are completing on behalf of them is correct. And again, screenshots for proof of benefits, anything like that, will be accepted by legal aid. They have relaxed the rules during this pandemic for it.
Yeah, I mean, there's no doubt. I think historically, legal aid department has been a little difficult to deal with in terms of evidencing various payments and savings and benefits and what have you. So it's actually reassuring to know that they've become more flexible and are sort of moving with the times, certainly to sort of facilitate this sort of thing. I suppose there will still be people who will fall outside of the legal aid limits of eligibility, which would make them private payers. Um, what what advice do you have for anyone who feels that they probably will definitely fall outside legal aid? What do we do with them?
Well, we would offer a fixed fee arrangement, so we can give them an initial fee and say this is what it's going to be, and we would then come to an arrangement with them. They can make monthly payments, weekly payments, whatever would suit them, to cover the costs of that. But that would all be upfront, and it would be set up upfront for them so that they would know, and there wouldn't be any hidden costs in that.
Yeah, I mean, I know you and I have talked about this in the past. You're head of department, I own the firm. So between the two of us, when we do look at these cases, and especially at the moment where lockdown has really sort of brought a lot of these domestic abuse issues into sharp focus, I think we're always fairly flexible, but I think at the moment we are particularly flexible in terms of payments, so that the main thing is people get the protection that the law will actually afford them.
Yeah, yeah,
Okay.
that's exactly it.
I suppose then the big question is what happens now? People, obviously, anyone watching this and who've been affected by any of the things that we've talked about, what can they do to speak to you?
Okay, well, there are various ways to get through to speak to me. So, my advice would be certainly contact me initially just for a chat. So you can do that three ways. So you can do it via email at hello@armstrongsolicitors.com. You can phone our office and you can be directed through to me. I'm not in the office, but I am still available on the telephone. Or you can go through our website. There's a callback request there. Put your details in and I'll certainly make contact with you. Initially, probably I would give you a ring, have a chat, then set up a Zoom meeting to go through everything with you, if that's possible, if that's what you want to do, and we can take it then from there.
Okay. Yeah, I mean, obviously at the moment, most solicitors' offices are or should be physically closed at the time of recording, but most firms are still working away from home. And I mean, we have the technology that we can do these things. I mean, you and I are probably talking 20 odd miles apart. So distance is no object. If someone needs advice, we can put them we can put you in front of a camera, and hopefully they can get in front of a camera on their phones, and we can make contact. As you say, I mean, it is the most important thing is that people get advice. They take control of the situation that they're in. And I mean, as I say, Sharon, you've now been part of Armstrong Solicitors for, gosh, 11 years this year, aren't we? And you've been with us from the start. So, we've seen that family department grow from nothing to be a force to be reckoned with. So we know that if people can make contact with Armstrong Solicitors, they will get through to the right person. Is there anything else that you want to say at the moment? Do you feel that this is still going to be an issue? I mean, I think we're also going to see an increase, unfortunately, in separations and the matrimonial side of the practice. Do you have any sort of just a quick word about sort of separations and divorce? Is that something that can happen while you're in lockdown?
Yeah, that can still happen. Certainly the courts are not functioning to full capacity at the minute. They're not deeming divorce proceedings as an urgent matter at present, but that doesn't stop people coming again, make contact with me to get initial advice. You can certainly start the process off for the divorce, be that if someone has decided that they definitely want to go down the divorce route, they can start their legal aid application, for instance, if they are going to be eligible for legal aid. We can certainly start that process, that when the courts are back up and running, the paperwork is there and it's ready to go. if people don't feel that they are wanting to divorce at this stage, but will want to separate and sort out their finances, that can be dealt with. As you say, the solicitors' offices are still up and running, albeit most people are working remotely. So they can, the separation can start, their partner can get representation themselves, and the two solicitors can start dealing with things and try to move matters forward.
Yeah, and again, I mean, the whole point is, initial advice. I know from your calendar that, you do have a fair few appointments where people are getting initial advice. They're separated from their spouses or their civil partners, and they just want to sort of be equipped with some knowledge before they go and make potentially very permanent or long-standing decisions. So we're still open to do that, obviously.
Yeah,
Excellent.
that's exactly it. They certainly do need to get the initial advice first of all, so they can make a decision of what they want to do.
Yeah. Okay. Well, listen, thank you. It's great to catch up on what you're doing in your side of the practice. It sounds as if you're going to be relatively busy over the next couple of weeks and months. I mean, obviously, we set this firm up to provide services to people who need it at sometimes very difficult points in their life. These are one of those points, and I'm glad that you're on board, and we have the confidence, and our clients will have the confidence that you can act for them and get their rights protected. So thank you for that, and I will speak to you again soon.
Thank you.